Hello ladies and gentlemen, and welcome to my YouTube channel Insurance Education. My name Raymond Macmillan, and as I alluded to in my last video, in today's video I'd want to tell you about a term. It's called Privity of Contract and how it applies in insurance. Let's take for example, this being an insurance contract. We know that an insurance contract is a contract between the insured and the insurer, and that contract can end up in court. So therefore, what privity of contract says is that only the parties named in this contract can avail themselves of any rights or remedies under the contract. But ladies and gentlemen, there is a situation, there's an act of law called Third Parties Rights Against Insurance Act, and this is a 2010 act. It's a UK act, and we know UK leads the world in insurance knowledge and practice. What this act does, it gives the insured or a third party from the insured's viewpoint, and I'll give you an example soon, the right to go against the insurer even though the insured company goes bankrupt. So let's take for instance a courier company with two drivers, and they are named in the policy document as drivers, and there's an incident where they were involved with an accident, and before they can be compensated, their company goes bankrupt. It means that that action, if they do not have any other rights, will die, and those third parties, those drivers, if presuming there were two, or let's say they're just one who got into an accident, will go without compensation. I love this act, the Third Parties Rights Against Insurance Act 2010. It gives that party who is named as a driver in the document, on behalf of the company who went under, they can now bypass that company and go straight to the insurer seeking compensation. There was a previous act in 1999, it was the Contract Rights Against Third Parties, but that didn't really give the insured, any real advantages. All that said is if the company goes bankrupt, the third party who is bringing that action would now have that right to go after that company, the company which went bankrupt, but they would have to bring the company back to life, and then the administrators now would have to add this third party who is seeking compensation just as a list of an ordinary third party. Can you see the difficulty there, where even though the company is brought back to life and the insured, who or the third party who is claiming, is listed as a legitimate claimant, but you are just one of them, that means there is no priority given to you. So that act, the the Contract Rights Against Third Parties Act 1999, didn't favor the insured. But this new act, which is the Third Parties Rights Against Insurers Act 2010, is very good for all third parties, where you can still get compensation even though the company has gone under. I trust this is helpful to at least one person. If you like what you've just heard, may I invite you to click the like button below, and how about subscribing to our channel if you haven't yet done so. And also, if you want to have access to my next video, please just click the notification bell above. Thank you for your time, ladies and gentlemen.